that topic because I know he's been right in the middle of this. Our two speakers this evening, of course, Justice Stephen Breyer requires very little introduction to this group here. He is a frequent visitor at the Aspen Institute, an Associate Justice of the U.S. Supreme Court, and a true Renaissance man, not only a justice with a brilliant mind, but also a scholar, all right, whatever, we know him. We know him. The Honorable Dame Sylvia Cartwright is a trial chamber judge in the extraordinary chambers in the courts of Cambodia. Dame Sylvia is a native of New Zealand and practiced law there prior to becoming the first woman justice of its highest court, which is a familiar thing to us here at the Aspen Institute because one of our lifetime trustees is Sandra Day O'Connor, the first woman justice of the U.S. Supreme Court. And in the green room, we were talking a little bit with Dame Sylvia about some of her experiences, and I am going to quiz her a little bit about the experience of being the first. And I must say that hearing a couple of her stories, they sounded oddly reminiscent of stories that we've heard from Justice O'Connor. Dame Sylvia has had a number of remarkable experiences in her legal and judicial career. Among them was leadership of the Cartwright Commission, which dealt with a case of grave breaches of ethical standards in medical practice in New Zealand, and we'll ask her a little bit about that. Then in August 2006, began to serve as one of two international judges in the trial chamber of the extraordinary chambers in the courts of Cambodia. So with that introduction, we're going to launch right in. This will be a conversation. We will open it up to questions from the audience for the last 20 minutes or so, but we'll lead off with a few questions. And the first one is to Justice Breyer. Justice Breyer, is the fact that the United States has not, well, after signing the ICC, has not actually ratified the ICC, does that pose a problem with respect to our relationship to the international justice regime?
Well, there isn't a relationship there. And but we're not the only country to have this problem. France had the problem. And the problem is that, I guess, there are a large number of people here, and the military itself has said, people there have said they're worried about being hauled up for things that they consider they shouldn't be hauled up for. And I see the point. France had exactly the same point. And what they did is they worked out some kind of arrangement so that France could withdraw if that turned out to be so. And it satisfied the military, because they thought if this turns out to be a nightmare, we can not do it. And so this is a job for, it's not a legal question that you can ask me, it's a question I'd ask the diplomats. I mean, isn't it possible to work out some kind of arrangement that gets the people who are worried about this a little bit less worried? And I don't know why it isn't possible, but apparently so far it isn't.
In your concurring opinion in the Kiobel case, you stated that torturers and perpetrators of genocide are fair game wherever they're found, and urged that the U.S. must not become a safe harbor for violations of the most fundamental international norms. As I'm sure you're aware, human rights groups have sought and sometimes obtained international arrest warrants for President Bush, Secretary Rumsfeld, Cheney, and now President Obama on allegations of torture and war crimes. And Tzipi Livni of Israel was forced to cancel travel in the U.K. because of the threat of a citizen's arrest. Does that risk of the application of universal jurisdiction color the Supreme Court's jurisprudence in this area?
Well, that's partly the answer to your first question. There are people who worry about that with cause. And therefore, there has to be an institution set up in a way that will minimize that concern. Now, what we have is a statute that comes from the time, it comes from 1790 something, I think Alice Henkin probably knows. I mean, people actually, I don't know this area. There are a lot of people here who do know the area. I mean,
and they'll have a chance to talk.
Yeah, but I'm fine. And Margie Marshall's here. She knows the Truth and Reconciliation Commission. But I mean, what we had is a statute that was passed at the time of the founding of the Republic. And it says, it's called the Alien Tort Statute, And it says that a person, an alien, may sue in the federal court for damages where the damages were caused by a violation of international law. Judge Friendly said that statute is like Lohengrin. Nobody knows where it comes from, and nobody knows what it means, and nobody knows where it's going. But there it is in front of us. So what I've said is, in looking up the history of it and so forth, it was aimed at pirates, really, in part. And in part it was pirates. If you found a pirate, you could hang him, but also you get damage out of him if you catch his ship. And that was true wherever he was found. So the question becomes, in a simplified form, but I think accurately, who are today's pirates? One, you have to be careful about who they are. Not every bad thing. They're necessary to make distinctions, and some are worse than others. Judge Cartwright has one example right in front of her. And so also worry about and write about, I use this as a little bit of a commercial to urge you to do it, there is no Supreme Court of the world. And the Supreme Court has one virtue, whatever you think of its decisions one way or the other, and that is it takes different views of different judges and it says this is it, and it harmonizes them. And there is no Supreme Court of the world. So you have to have a way that you will get a uniform kind of interpretation of what's going to go under the statute, for example. And there is a notion which provides for that. It's called comity. So what I wrote about in that opinion is I was trying to figure out how you could have a system that would both make this enforceable against certain things that are really pretty bad, and also allow it to work out so you don't capture Henry Kissinger 19 times out of 20. I mean, you know, that's not going to work very well, and it's never going to appeal to the American public. And there are ways to do it, but it's complicated and difficult, and I guess that is what we as lawyers and judges are paid to do. Figure out how to do this. And I don't necessarily claim to have done it right, but that was my effort.
Judge Cartwright, so the hybrid model of Cambodian judges and international judges that was selected for the ECCC, how well has it worked compared with other models, with the Yugoslav tribunal, the Rwandan tribunal, or the ICC?
Well, the hybrid model arose out of the very difficult negotiations to establish the court in the first place. They went on for years, and Ambassador Sheffer has been deeply involved in that and has written about it. The hybrid model is a result of those very difficult and very politicized negotiations. The Cambodians asked the UN to establish this tribunal, but very quickly it no longer suited their political ends, and I think from that point on they've done as much, the leaders have done as much as they can to neutralize the tribunal and keep it within the boundaries that they would like to see it. So it's not a perfect model, but then I would suggest that none of the tribunals that have been established, Rwanda, Yugoslavia, Sierra Leone, are perfect models. They are all the product of the political, judicial environment. So how well has it worked? At some levels, extremely well. The Khmer Rouge wiped out the intelligentsia. So there are no judges, there were very few judges, if any, that survived that era, and very few lawyers, if any, who survived. So there is no basis for building a judiciary and a legal profession in the country. This tribunal gives an opportunity to show how an ordinary court civil law model works. Though it's a very complicated version and will never apply to the ordinary domestic trials that the Cambodian judges will run. Because it's based on the French model of the civil law, judges aren't accustomed to reasoning their decisions. So the fact that we reason our decisions has been a very good model for the local judiciary, and I was very pleased to hear recently that some have actually started to give reasons for their decisions, which is very encouraging. We work together very well in the trial chamber, the Cambodians and the international judges, And I think that that has had its positive outcomes. The President has talked to me many times about the lessons he wants to take from the way we have run things back to the domestic jurisdiction. For example, he no longer wishes to hear sentencing information while the trial is ongoing, that is before conviction. Personally, I think if nothing else, it's a complete waste of time, because what if you acquit? You've just wasted time hearing all this character evidence. So he wants to stop that, and he will have what they rather scathingly call a bifurcated trial, which is hearing the evidence that goes to conviction or acquittal and then having a sentencing hearing later. So that sort of example, I think, is very useful. The legal officers who are Cambodian are getting better, but there is no way they're independent, because there's such a hierarchical social model there that they would never contradict one of the judges and say, I don't agree with you, whereas our international ones do that all the time. I think that having it based in the country has been very important, because the court itself seats about 500 people, and most days it starts off being full. They bus in villages, they bring university students and judges in training and so on, and the court is very, very busy. I think it's something like 200,000 people have now been through the court, but as well as that, it's very broadly publicised throughout the country. So a lot of people have heard a lot about what actually happened and why, because these are the questions that the local people simply still don't know about. And it has certainly stimulated a great deal of discussion about the Khmer Rouge era, which can only be for the good. So in that sense, it's been very good. The contrary is that it is susceptible to political influence. If the trials had been held in The Hague like the other tribunals, that could not have happened, but then neither could the people have learned so much about the events in country. So it's a mixed outcome.
Some critics have noted that at Nuremberg only 22 perpetrators were convicted of the death of 6 million, and in Cambodia the proceedings have concluded for 3 defendants in the death of 1.7 million. So that's a utilitarian calculus. Given the extreme poverty of the Cambodian people, was the court process, which came at the cost of, I think, if I'm correct, about $200 million at this point, the right investment in the future of Cambodia?
Well, a lot of Cambodians say it would be better if you had put the money into schools, into hospitals, to roads and so on. But, of course, the answer to that is it wouldn't have happened. The donors would not have given money for those projects. They're already pretty much propping up the Cambodian economy as it is, the international donors and the NGOs. Yes, it's a huge investment, but after all, the Cambodian government did ask for this, and I believe that in the long term, not in the short term, but in the long term, it will be seen as a very useful investment. It has certainly resulted in the Cambodian people knowing a great deal more about the Khmer era than they would ever have known, because it wasn't talked about generally, and for the first time it's a part of the school curriculum. It was never previously, and I think the surveys of the Cambodian people are that on balance they think it's been good. But there is still that concern about the sheer cost of it in a country that is, as you say, incredibly poor.
What about the role of the civil parties, the victims? You mentioned in the Green Room that that's a unique attribute of this court.
Well, yes, it certainly is. Victims in the civil law process have a formal role. They are civil parties. They are parties to the trial, just like the prosecution and the defence lawyers. They have access to all the material. They can promote witnesses to be called. They can question witnesses. They can give testimony. They have a very central role in the trial. But it would take a very long time to explain about this, but there are about 4,000 registered victims in case 2, and there is absolutely no way you can run a criminal trial whose focus has to be on the behaviour of the accused if you've got 4,000 extra parties to contend with. And of course there's absolutely no way they can be individually represented. So we've had to modify the rules significantly, and that's been very disappointing for the victims. But the reality is it would be impossible to run the trial and to get to any conclusion if we did it in the classic civil law way. I think it's very important to have victims as the centrepiece of any criminal trial, but I feel quite strongly that the way we've gone about it in these trials has not been an ideal solution. We've done our best, and victims have certainly been given as much attention as we've been able to manage, but a criminal trial has to focus on the accused, not on the victim, the broad range of victims' experiences. And also, 4,000 victims is just a drop in the bucket of all the victimisation that actually occurred. So in a sense they're self-selected and they're not representative. We've had quite a significant number from the diaspora, and the ordinary people just don't have the time, the money, the mental and physical stability to come and participate in the trials. So it's not an ideal model, but it's worth building on for future international trials, and I know the ICC is trying to do that.
Justice Breyer, James Sylvia spoke a little bit about the culture of the judges in Cambodia and what a challenge it is to change culture. You have written and spoken quite a bit about the culture of rule of law in the U.S. and how we went from the early stages where we did not have a guarantee that the executive would carry out the rulings of the court or the police would carry out the rulings of the court, which continues to be a challenge in many parts of the world, versus the U.S. approach where a president can say, well, I don't like the opinion of the court, but I'm going to carry it out. How do countries develop that culture of respect for rulings of the judiciary?
Over time. That's why I think it's so interesting. But I mean, I have more questions than I have answers. I think it's very interesting what's happening in Cambodia, and we have here, as I look around, people from Wald, Judge Wald was participated in the tribunal for former Yugoslavia. Chief Justice Marshall, who was Chief Justice of the Mass SJC. There's a great deal about the Truth and Reconciliation Commission. That's another approach. Judge Cartwright knows about this approach in Cambodia, and Alice Henkin knows very well about the ICC. She's studied it for all this entire area for years. Which is the better? I don't know. Which has the strengths and weaknesses of what? Match them up to different problems, or are there other models? But I do think the analogy is a strong one that you draw. In my own mind, these just represent tentative steps, which we hope will continue, at least I do, to bring a degree of what I'd call the civilizing impact of the law to bear upon totally uncivilized and barbarous behavior. And to do that is not going to solve the problem, but it's one step that can help. And so when I think about this, I'd say, well, how much do we expect? It sounds as if is the glass 1% full or 99% empty? I mean, that is what it is. And when I hear Judge Cartwright speak about this, and they have one or two defendants left, or they don't have that many before the ICC, well, then they don't. But still, I think the effort is why? Because people, just the reasons you said. You want to know? I brought this because it moved me. I brought what Justice Jackson said when he went off to Nuremberg, which was very controversial at the time. I mean, these are ex post facto laws. They weren't laws at the time, and why not just, as Churchill said, take them out and shoot them? And what he said, I have it here, I think, if I can find it. Wait a minute, I wrote it down somewhere, and here's what he said. He said, this work, he said, and this is a quote from him, the Nuremberg work, he said, was the most important experience of his life. He'd been Attorney General. He'd been a member of my court. But it is infinitely more important than my work on the Supreme Court or anything that I did as Attorney General. He said his object, and I just want to know if this rings a familiar note, he said was to make explicit and unambiguous in law that to persecute, oppress, or do violence to individuals or minorities on political, racial, or religious grounds is an international crime, for the commission of which individuals are responsible, they can and will be punished. And he added in his opening speech, which is a great speech and well worth reading if you've never seen it, at the Nuremberg Tribunal, he said, the wrongs we seek to condemn and punish have been so calculated, so malignant, and so devastating that civilization cannot tolerate their being ignored because it cannot survive their being repeated. That 4 great nations flushed with victory and stung with injury stay the hand of vengeance and voluntarily submit their captive enemies to the judgment of the law is one of the most significant tributes that power has ever paid to reason. So, when I hear what you're doing, I think, bravo. You know, and maybe it'll only be one person, and no, the victims aren't going to be, but better some than none. I mean, I think that's the point, and you studying this is a good thing.
Well, one thing the Cambodian people really like about the tribunal is seeing 2 remaining former leaders unable to control their own lives anymore. They're in captivity. They're getting a trial, which the Cambodian people certainly didn't get under the Khmer Rouge, but they really like seeing them being held accountable. And I think this is an important lesson as well.
And people over here, look, we're here, we're not in Cambodia. And we know about it. And that must be true throughout the world.
Well, Justice Breyer, I wasn't going to raise Justice Jackson, but I can't resist asking, why do you think, or do you think it would be ever possible for a Supreme Court justice to take leave to do something like what Jackson did?
Judge Wald did. Well, no, you had left by then. That's true. Yeah, all right, so you then did. Well, I don't know. I don't know. But Chief Justice Warren took the leave, or he did the work on the Warren Commission while he was still Chief Justice. I personally think it's not such a bad idea, but there are constraints that might prevent it now. I don't know.
Just one more follow-on question, and then we're going to back to Judge Cartwright. What role can U.S. judges usefully play in peer engagement and in education in nations that are trying to build independent judiciaries? And is there a role for the U.S. Justice Department, the FJC?
Well, and they're doing it. There are all kinds of things that go on. I mean, one of the things was when Judge Wald went over there. I didn't realize you had to just quit everything in order to do it, but I'm glad you did. All right, so there are committees in the Judicial Conference so that federal judges actually go to the places and help. Now, to help, I think, is not just taking some judges from that country and bringing them on tour in a nice trip to America. I think it helps more when Judge Stearns up in Massachusetts spends quite a lot of time actually in Hungary, Turkey, and there was one other place he'd been, and he gets to know the people. And gets to know what their culture is like, because you can't tell them what to do. They have to absorb what's useful for them. And the Justice Department has lots and lots of they have representatives in different countries, but the State Department has a whole section that John Jasek runs, and they try to take judges from America and send them to other places. But you can't go there thinking you're going to tell people what to do. And what I usually say to the judges there, I speak to judges from Ghana or from Ouagadougou, that was the capital of Burkina Faso, and they all ask similar questions. Why do people do what you say? You know, that's a question probably we don't think about that so much, but they do, don't they? You say, my God, it's a history. Don't talk to explain this history. Well, it's hard to get people to do what judges say. The reason we're there is because Alexander Hamilton and a few others thought that don't turn over to the president the power to say what he's doing is lawful. Because he'll always say it's lawful. And maybe you should turn it over to Congress. No, they'll do it as long as it's popular. But they're experts in popularity. But the Constitution is for unpopular people just as much as for the popular ones. So we'll bring in the judges. And then it takes 200 years before people really get into the habit of following what they say. Well, all right. Better than the alternatives. And you try to explain to people that. And you have the same kind of experience.
Yes. I love the phrase, the tyranny of the judges. Compared with a dictator, it's nothing.
Right.
Well, I want to turn to the question of money, which is very important with respect to the ECCC. But before I asked Judge Cartwright about that, Justice Breyer, I do want to ask, with the government shutdown and sequestration and all of that, is that having an impact on the court? And is it having an impact in the court in a way that in any sense will impede
Supreme Court?
Yeah.
Well, we had a rainy day fund where they actually saved money for the rainy day, and then it rained and we had the money. And then by the time, before that money ran out, they ended it. So it didn't really affect us.
And the lower federal courts?
The lower federal courts, I think, some employees of the lower federal courts might have been affected because they were trying to have rolling layoffs or whatever. But I think they've gotten past that now. My impression is. I'm sure that not everybody. Unfortunately, the lower ranking the employee and the less money that they earned, the more likely it was they'd be laid off. That's not a very good system for the morale of any institution. But I gather that now it's no longer shut down.
And the morale at the ECCC, you ran out of money at a certain point. You want to talk about, was it a mistake to create the court as a voluntary funded court?
I don't think there was any choice. I think after the cost of the Yugoslav and Rwanda tribunals, the UN chose to have a voluntary contribution model, which it was already known would not succeed because it hadn't in Sierra Leone. It's impossible to run a court on donations, and I have to say I really admire Ambassador Sheffer for taking on the job as fundraiser in chief when he has skills in different directions that would be far more of value to the court and to the development of the law. But the reality is that he has to spend a huge amount of time raising money for the international side as well as trying to get the Cambodian side funded. The morale is frequently very bad. Recently, for the second time, the court staff on the Cambodian side were not paid for about 3 months, I think it was, at which point they started paying the staff again, although my driver still hasn't been paid all his money, but they didn't pay the judges. So the judges were getting very twitchy about this, not surprisingly, and they've now been paid but not for the back pay. So I think they're owed about 2 months or maybe 3 months pay, but they're prepared to, they've not stopped working. Now, once the court came to a halt because the interpreters and translators walked off the job and we can't operate without them, so we've had strikes, we've had a lot of unhappy people, and on the international side it's also had an enormous impact because the international staff have contracts for only 3 months, and given that it takes, you have to have a contract to get a visa, to keep your visa in Cambodia. It takes 6 weeks to get a visa. For half the time of your contract you don't have a visa. Your passport is not with you because it's away getting a visa. We've had incidents where people have needed emergency treatment, medical treatment, and you can only get that out of the country, and they haven't been able to leave the country because their passport is with the visa office. So it has a massive impact whichever way you look at it, but probably the most important is that you can't expect people who are not being paid to keep coming to work. They have to find their income from somewhere else, and that can be seen to be corrupt. If you want judges to focus on judging, you should take away worries about money. And the Cambodian judges have not had an income for a significant period. There have already been many allegations of bribery of judges and so on, not within the ECCC itself, but in their ordinary domestic jurisdictions. And in fact, it's very common for judges to take money from happy litigants. In fact, I was told not so long ago that the just judge in Cambodia, domestic judge, I don't mean ECCC judges, the just judge is the one who takes money from both sides and then decides according to the law. I think that's probably apocryphal, but it makes a very good story. But the very first experience I had with the Cambodian judges was when we came to start drafting the rules. And the staff had done a program which had us working on the Saturday, and the president of the court, the Cambodian president of the court, came through translated, but the one word I picked up was moonlighting, and apparently how could he possibly work on Saturdays, because that's when he earned his money, and we all thought it was taxi driving, but we're not sure. You know, these people are incredibly badly paid in their domestic courts. They can't possibly survive on the pay they get, and at least in the ECCC they're paid a pretty good wage, but it's got to be paid, or there will very readily be, at the nicest way of putting it, is a lack of independence. So morale and all these other problems are massive in these situations.
On a somewhat cheerier note, if you're willing to talk about it, can you share a little bit with us how these trials are impacting the political picture more generally in Cambodia? Is it building some sense of independence or some sense of the people of Cambodia as citizens as opposed to subjects?
Well, what I said earlier is that I believe the trials are having an impact. They're showing how a fairish trial can be conducted. I don't believe there's such a thing as a totally fair trial, and it's really difficult in this environment. The people are appreciating it. Certainly the surveys of the Cambodian people show a rising trust in the court. So that's important. Politically, it is not easy. The Hun Sen government would quite like us to go away now, please. And they certainly don't want any more trials after the one that we're conducting. It could be said that the negotiations between the UN and the royal government of Cambodia left a group of potential accused handed over to the court on a platter, and by no means are we going to try all of those ones, let alone anyone beyond that small negotiated group of, I think, 5 to 10 people in total. So it's certainly not, as I said before, a perfect model. Politically, the Prime Minister has on a number of occasions made comments that have had an impact on our ability to be seen to be objective, and we can't do anything about that except constantly tell the accused, well, we're not influenced by it. We don't have a jury, so they're not influenced by it, so just ignore him. But he won't stop doing it. I don't think he keeps to his speech notes. I'd hate to be his speechwriter.
Judge Cartwright, in the back, I did ask you a little bit about your experience as a first, as the first woman justice on the High Court. And you told me a couple of stories which I think seem funny in retrospect, but perhaps not at the time, that perhaps you'd like to share with the audience about some of your earlier experiences.
Yes, well, when I was a new graduate, I think there were only 2 women in the law faculty studying law at the time. That's how old I am. And when I tried to get a job, I was turned down repeatedly. Once because of all the trouble a woman called Ethel Benjamin had caused. She had graduated, I believe, the first woman lawyer anywhere in 1897, and I'm not quite that old, so they have very long memories. They had to pass an act of parliament to allow her to practice law, and she was a constant thorn in their sides ever after, which was very good, but it didn't make it easy for me to get a job 70 years later. But I did get a job against a lot of stiff competition in one of the better firms in the city that I was living in. There were 11 male candidates and me. My then employers took great delight and continue to tell the story that the reason I was selected was because I had the best legs.
There you go. All right, we have...
I got paid less than the other men.
Oh, okay. Even your legs couldn't get you.
Not a thing. Didn't do me any good at all.
Well, we have quite a distinguished audience, and I don't want to put anybody on the spot, but there are 2 or 3 people who I'd like to invite to ask questions if you have any, and I'd like to start with Judge Wald, please. Okay.
Judge Cartwright, I wondered whether or not the likelihood that the extraordinary chamber will finish with the end of the trial that you've just heard the closing argument. And I think it's widely reported in the press, et cetera, that both the problems of getting money, which David is working so hard at, but which has to come from volunteers, and also the repeated hostility of the government. Do you think the fact that Justice Breyer, and I agree with him that 1 step at a time, 2 steps are better than no steps, but the fact that the tribunal may have to close down because everybody is, everybody who has the money and the power is against it, is going to be a negative in terms of its long-range impact on the country?
Well, it depends on how the tribunal stops. One way will be because the funding simply is no longer there. I think with the current trial, we'll stumble along. And in the current trial, because it's such a massive indictment, the trial chamber judges estimated it would take at least 10 years. And we felt we didn't have that time, so we severed into chunks, more manageable chunks. That's been very controversial, but we felt that it was better to have one verdict than none. Unfortunately, the Supreme Court has not been very helpful in endorsing this approach either, so this may fall apart, and I certainly think that if we manage to do more parts of this trial, there'll never be another severance order, so what will happen is the 2 remaining accused will die or become unfit, and so the trial will just peter out. So there's funding problems, there's the age of the accused. Personally, I don't believe that cases 3 and 4 will ever get off the ground. The accused, who I don't know who they are, I'm not supposed to know, but of course it's widely known in Phnom Penh who they are. They're not as old as the current accused, so they may last, but I don't think the funding will be there, and certainly politically, domestically politically, it's not going to fly. We have another problem, and that is that unlike the other tribunals, we have no leadership model, no judicial leadership model, no administrative leadership model. So management is a massive problem as well. And we stumble from management crisis to judicial crisis all the time. And that equally could cause problems. This is not something that's so obvious outside the court, but without leadership, it's a very difficult court to run. Well, I don't know who runs it. So I think that we could stumble to a close, and it'll be like the last judge out, please switch off the lights. You know, it's for whatever reason. So it depends on how the close to the court is managed. And just the other day, OSJI, the Open Society Justice Initiative, published a paper saying, you know, it's time to take control of the exit strategy. And I've believed this for a long time. There needs to be discussion about it rather than literally limping out the door of the court and taking the UN flag down and going home. I think we need to have a dignified way to finish this court.
I'd like to call on Ambassador Sheffer to offer some perspective on all of this. And David, you also were intimately involved with the trial in the former Yugoslavia where Richard Goldstone was such a strong presence. Would you care to offer your perspective on where we're going next here?
Well, thank you so much, Merle, and I'm so honored to be in your presence tonight. I think tomorrow morning I have an opportunity to have a discussion with Judge Cartwright before the audience tomorrow morning, so I won't belabor some of those points. I think what I can add is that we had a very constructive meeting today at the United Nations, which Ambassador Rapp, who I know is in the audience, was there as well, representing the United States. And there is a certain growing attitude among some very significant countries that there is an importance in following through with the mandate of this court. Now, there are some countries, well, actually just one in particular, that will hold a very negative attitude about that. They want a very immediate exit strategy. But actually, other countries are not asking for that. So I think it's going to be very interesting over the next year or two as we work through a very ambitious budget for the next 2 years, and we see whether or not we gain the financial support quickly enough so that we can have 12-month contracts, we can stabilize the court, and we can have more confidence that the court will not be disrupted constantly with these particular crises. We'll see over the next 6 months or so whether or not this can be stabilized, but I was actually quite encouraged today by the attitude of governments. Now, they have to follow that attitude with the money that makes it all possible, and that money has to come in quickly enough. And that's the challenge that we're constantly facing. It is, as you say, Judge Cartwright, applying one's talents to simply raising money for a court is I never thought my career would go in that direction. But the fact is, in international justice, money is incredibly important. You have to have the money to make it work. And that's just a reality of the international justice system.
Okay. Why don't we open it up to the audience? Questions? Amy.
This is a treasure to have here in Washington. Thank you, Merle. Thank you both. I'm wondering...
we're having some trouble hearing.
Can you hear? Can you hear me?
Is it
Yes.
on?
Okay. So there are many places in the world where there have been atrocities and there is still no recognition, much less justice. And I so appreciate what you said about the coming at some point to the point where you are having a very good exit strategy. It's very important for the country, the host country, reluctant hosts, but the host country, and especially what you're leaving in your wake, which is hopefully a judicial system that is awakening to the right way to do things, to justice. I hope that you will be sharing your talents in other trouble spots. And it may not seem so attractive right now, but I'm wondering what kinds of lessons have you learned, aside from the very difficult trouble of fundraising, which I can appreciate, but what are some of the other nuts and bolts and maybe some broader issues that you can take with you?
Well, the first that springs to mind is the chance to immerse myself in a totally different procedural model, the civil law model. And that has been a fascinating experience. It's a very cumbersome model, much more cumbersome than the common law model, but I'm not saying that it shouldn't be used again. I'm just saying it perhaps should be streamlined a lot more, like we've had to do for the civil parties than the victims. Now that's a judge speaking. It's been really interesting, you know, doing a different way of doing trials. But on the broader perspective, I strongly endorse the quote that Justice Breyer made before about ending impunity. Now, we'll never end impunity, but we need to be able to say to the former and current tyrants of the world, you might think you can act like this because you have impunity and you have the bigger army or whatever, but one day you may be captured and tried. I think it must have come as a huge surprise to Pinochet because he wasn't expecting it. But for the likes of the Khmer Rouge, this has been so important in Cambodia for the people to begin to understand who it was that developed this dreadful, dreadful regime, why they did it, and the leaders have had every chance to, the accused in this trial have had every chance to explain, and they've occasionally done so, not very often, but they've occasionally explained, and it hasn't been convincing. My husband often comes and sits in the body of the court, and he says you can hear them all around him saying, "Oh, what rubbish," and things like this, you know. And certainly on the bench, the judges around me make really, you know, I can't understand what they're saying, but I imagine it's very rude comments about some of the evidence. And you can hear them sort of growling in antagonism to some of the things they're hearing. This is incredibly important to the people to see this in action. But for me, the most important thing is no impunity. We can't even promise that because there are a lot of dictators that will get away with blue murder and will never be tried. But perhaps the fear of being tried one day might make them moderate their actions a little more. It doesn't seem to be working in Syria, but you never know. I don't think we can promise never again anywhere in the world, but we can at least promise occasionally that one tyrant will be put on trial and humiliated, no longer powerful, shown off to the people for the terrible philosophy, the bad thinking that goes into the decisions that they make, the lack of care for their people. They say they've done it because they love their people. Nonsense. They've done it for personal power or ideology or whatever. So these are the most important lessons from a trial like this. I don't think I'll be doing anything after Cambodia, though.
Chief Justice Marshall.
Judge Cartwright, this may be an entirely inappropriate question, and if it is, just disregard it and ask Justice Breyer to answer it, perhaps. I'm provoked to ask it because of what you've just said about your fellow judges. In the common law tradition, judges tend to be schooled to maintain a very neutral face and not to react to the evidence as it is coming in and to remain looking impartial, even if they're feeling impartial. In the Truth and Reconciliation proceedings, which were entirely different, from time to time, Archbishop Tutu, when there had been particularly powerful evidence, would simply stop the proceedings, either to weep himself or to permit some kind of outpouring of emotions because the testimony had been so powerful. I wonder personally how one can go on for as long as you have been going on, listening to this quite extraordinary evidence, because mass genocide, or the accusation of mass genocide and crimes against humanity, cannot be easy evidence to which to listen. So the question might be not, do you keep a straight face on the bench, but do you participate in yoga or something?
No, I eat the wonderful French food that Phnom Penh offers. It's much easier for me and for my international colleagues than for my national colleagues, all of whom lived through this regime. One of them was a young boy at the time, and he told me, I have to say I don't ask my colleagues what their experiences were, but from time to time they volunteer the information. I think it's just too painful for me to cross-examine them. But he told me that his parents, who were both teachers, for a long time would leave their homes with their children every night and go and sleep in the jungle because it was safer there. And the jungle in those days was full of snakes and tigers and everything. But his job during this period, and he wasn't educated, they stopped education altogether, was to catch mice or frogs in the paddy fields during the day. If he didn't catch any, he didn't get any food that night. Now, if you bear in mind that at the best, the people who were sent to these work, which was most of the population who went to the work camps, got the equivalent of this size tin of rice to eat each day, and that was at the best period. It got reduced, and sometimes they just got the water that the rice is cooked in. So if he didn't get even that to eat, an already starving child, it's worse for him. Now, not so long ago, we had a witness who was clearly ideologically on the side of the accused, and he was telling us that the children were happy to join children's brigades and search for food and do the tasks that they were assigned. And I sent a note to my colleague, this particular judge, saying, would you endorse that? And he just gave me a look that was, very sad. I know that other of the judges on the bench, one of them was forced to marry his wife. There was a lot of forced marriage during this regime. They chose the partners. He thinks that it wasn't such a bad thing because, after all, culturally, Cambodian parents often choose the bride and groom for their child. But he considered himself extraordinarily lucky because the woman, he was lined up at 2 o'clock, and I think there were 18 couples, and he was told he was marrying number 12 of the woman, and he felt very lucky because he recognised her. She'd lived in a village near him when they were growing up. They're still together, and they have 3 or 4 children, and when I went to the weddings of 2 of their children, these extremely lavish weddings, I wondered what he was thinking, what the parents were thinking when they saw their children married like this. But he too was led off the first day when Phnom Penh was being evacuated, shackled, because they thought he was from the former deposed Lon Nol regime. He was 18 at the time and a student. And someone called out, no, he wasn't with Lon Nol, and for some reason the Khmer Rouge released him. This is not heard of because they didn't care whether people were guilty or innocent. That wasn't relevant. And he couldn't get out of town fast enough to escape them, and he went to work on a dam site. And it was only when we were doing the first trial, which involved the chair of the Tool Sling, notorious Tool Sling prison, that he found out what had happened to the chief of his work camp, because he'd been taken away one day and he'd never seen again. And he was killed at Tool Sling. And the reason he was taken away was the dam started over there 20 kilometres away, and it was due to meet here, and it was off in the middle because they didn't use any modern instruments to work out how it should be built. So, a lot of the people were killed because the dam didn't meet in the middle. And I said, well, what happened to the dam? And he said, well, it's still just the way it is. And thousands of people died for a useless project like that. So their experiences, I don't know how they sit through some of it. And the fact that I can hear them growling, they don't lose the impassive face, but I can hear them. I think that's minimalist compared with what they could say and do.
Thank you very much for being here and for all you have done for the rule of law. All of us are captive of our own experience, and mine has been 25 years as a federal judge, both at the district and the Court of Appeals level, and a few years before that as a prosecutor. And something that immediately struck me as I looked at the timeline and thought about it, because I was actually in law school when some of these horrific events took place, is the difficulty that a court and particularly a prosecutor often face with an old case. The passage of time and all of the obvious problems that attend that, with witnesses disappearing and memories fading and evidence disappearing. Along with that, I wondered what kinds of problems of a practical nature like that you faced, but also whether delay or the long passage of time was a disadvantage culturally, politically, in terms of the stability of Cambodia, or whether it might have had some advantages that the society was looking back after such a long period of time at the atrocities that had been committed.
Well, the trials couldn't have been held until the late 1990s at the very earliest, because the country was still in civil war. The Khmer Rouge had retreated to near the border with Thailand, but was still a force to be reckoned with, and still there was killing going on and no political stability, or very, reduced political stability. So it wasn't possible until relatively recently to hold the trials. The first part of your question, the age of the evidence, not to mention the age of the accused, because we're losing them rapidly, as I said before, but the memories are still there because the experiences are seared into the memories of the people, but they're at a macro rather than a micro level. So people remember things that really, really had an impact on them, like the woman who was struggling across a central city bridge with her children the day Phnom Penh was being evacuated, and this was in the hottest month of the year, so maybe temperatures in the late 30s, early 40s Celsius. And she had her children with her, who later all died of starvation. And through the crowds, she saw a baby crying and crawling over its dead mother's body. Now, she remembers this and the deaths of her children vividly, but she doesn't remember a great deal about the work she did, except that it was very hard. She didn't have enough to eat. She was sick a lot of the time. She remembers the baby because she felt she wanted to get to it and look after it, but a soldier picked it up and physically tore it apart. That was pretty hard evidence to listen to. But the point I'm making is not to make you feel sad. It's that they remember the most remarkable events, not the day-to-day things. So yes, memories fade. We have been fortunate that the Documents Centre of Cambodia has accumulated a huge amount of material, including a lot of the confessions from the Tuol Sleng prison, a lot of the revolutionary flag magazines which disseminated the propaganda, and so we have a lot of material. The trouble is, as with any trial, is tying that material to these accused, this evidence to that accused, especially where they're the leaders who didn't dirty their hands with the everyday killings and so on. So yes, it has its problems. But at least in international law, there is no statute of limitations, whereas in domestic law in Cambodia, in most of the civil law countries, there is a statute of limitations, and we simply couldn't try these cases now because the statute's run out.
And for those of you who are not going to be able to go to Phnom Penh to learn about what the Documentation Center is doing there, our colleagues over at the U.S. Holocaust Museum are working on an exhibition. Mike, am I giving away secrets? When will that be mounted?
Not sure.
Not sure.
Soon. We work slow.
And that will be an exhibition which will bring to the U.S. some of the work that's being done by the Documentation Center, and I think it will be extraordinarily educational for all. Well, I want to thank everybody for being here this evening. I want to thank particularly our two speakers so much for sharing their insights with us. There are light refreshments outside, so please stay and chat.